Hello, and welcome to Regional Counsel, presented to you by the Singapore Academy of Law. My name is Nicole, and I'm your host for today. Regional Counsel is a series of short video podcasts on legal content catered to in-house counsel who are new to ASEAN regional work. This series is not meant to be a deep dive, but to equip in-house counsel with tips and tricks from experts of Indonesia law themselves to navigate the challenges faced when dealing with jurisdictional specific quirks. In today's episode, we'll be delving into the formation of contracts with Kalfin, partner of Jakarta-based law firm Arianto Partners.
Thank you.
Welcome, Mr. Kalfin.
Thank you, Nicole, for having me here.
Yeah, we're very glad to have you here today. Okay, so given that the aim of this podcast is to equip in-house counsel with some tips and tricks that they don't know because they don't know what they don't know and they're new to Indonesian law, would you be able to share with us some things that you would advise in-house counsel in contract formation, or in other words, contract development and execution?
Okay. In contract formation, I would advise that a key communication amongst internal parties that revolve commercial, technical, and also probably on the aspect of the compliance team, right? All those communication and collaboration within the organization need to be made. Otherwise, there's going to be a missing link in that contract, whereby the objective will not going to happen. So please avoid when you create a contract, you saw that hey, the title of this contract is a lease agreement. You just pull out a lease agreement and then you copy paste it without knowing the
commercial
the
intention.
commercial and so on and the objective. That would be very, very dangerous.
Okay.
I think one of the key is cooperation amongst the stakeholder within the company to establish a good contract is one of the primary or the most important thing that legal counsel need to do.
Okay.
So I learned that from more than a decade as a head of, as a legal counsel. So it proven that if we have those kind of collaboration, when we do a certain negotiation, it will be backed up by a certain division because they have the need, the contract to say like this, right?
Yes, all reflected in the
all
contract.
reflected.
Yes.
They have the need.
Okay.
So you are not basically alone on that matter.
Okay.
So there is a sense of, unity in terms of to get the objective of a company to get where the goal that is being aimed by the company itself.
Okay.
Yeah.
Yeah, I think that's something very useful for all legal counsel, whether it's Indonesian law or Singapore law, across the board. Across the board. It's very important to make sure that everything is aligned. The commercials, business, legal intentions are all aligned and captured in the contract. Is language something key to the formation of the contract and potentially its enforceability?
When you talk about enforceability, language. So, of course, language is something that you mean language by language in the contract, right?
Yes.
So it is mandatory for Indonesian entity or Indonesian individual or Indonesian company, government entity. They need to enter an agreement. If they need to enter an agreement, they need to enter it with Bahasa Indonesia.
Okay.
That is one thing that is mandatory. Then the second question will be, so what happens if the other party is a foreign party?
Yes, I think that's the hot question.
That will be the hot question.
Yes.
So, basis on the regulation, it opens the opportunity for us to create the contract on the bilingual format. One in the Bahasa language, one in the other, the foreign party language. We're open for that matters. And to be frank, basically, it's quite a serious in terms of compliance issue. Very, very serious.
Okay.
We have seen a few rulings, a few decisions that's actually not in favor of a party because of the lack of the compliance.
Okay. So it's not in Bahasa. Basically, the contract is in another language and it's not in Bahasa.
It's not in
Indonesia.
Bahasa and the other party, yeah. And the ruling is there. The decision was already there.
Okay, by the courts of Indonesia.
Yeah. So the risk is there. So again, then it's not only like, okay, I just made it in bilingual. No, it doesn't stop there actually. So you need to have a certain provision that actually support the bilingual version,
I see. Okay.
right?
Yes. So, for example, would it have to say that in the event of inconsistency between the Indonesian version
Yeah, it's a
and
part.
the English one, the one in Bahasa Indonesia will prevail.
Yeah, the one in Bahasa Indonesia
Will
prevail.
prevail at all
Yeah,
times. Okay.
yeah. So, okay, one tip that I can give to the legal counsel in the case that the legal counsel on the foreign side.
On the foreign side. Okay.
Okay, make sure that you checked and utilize the right resources to ensure that the wording
Mhm.
is actually the same with the Bahasa text.
Okay. So a most accurate
Most
translation.
accurate translation. But
Okay.
you can easily do it by the swan translator.
Okay.
Easily do it by that. It's not
Okay.
that difficult. It's only like, but you need to do that effort. You need to
Yes.
do
Yeah. Pay some money to have it accurately translated
yes.
to prevent it,
Yeah.
being
Yeah.
having a dispute over the interpretation.
Over the interpretation.
Okay.
But yeah, that one is quite a key on that front. So company need to be comply with the existing regulation in Indonesia, particularly when you are want to do a certain transaction in
Okay.
Indonesia. Of course, every country have their own law, have their own regulation, have their own compliancy,
Yes.
and of course, it's it's something that is normal, and for you for the legal counsel to understand that the importance of compliancy on each countries is somewhat that is crucial for the legal
Okay.
counsel to understand.
Okay.
Yeah.
So I'll just wrap it up for our in-house counsel here. It's very important, as Kalvin has shared, to have your contracts with Indonesian parties executed in Bahasa Indonesia.
Yeah.
And as Kalvin has shared, the courts have been very clear on this, that they will not enforce a contract that is not in Bahasa Indonesia. So this is really critical to to achieve parties' commercial intentions, and also in the event where you need to enforce the terms of the contract.
Correct. But I need to add that the flexibility, you don't necessarily need to make it only in Bahasa.
Yes.
You can make it in bilingual.
Bilingual,
Bilingual.
terms, one or
Yeah.
two or three copies in whichever
One
foreign.
or two, three language.
Okay, that's great to know.
Yeah.
But I think the key thing we have to remember here is that the Bahasa Indonesia version will always prevail
Yeah.
over the other
So Bahasa Indonesia,
contracts.
and then you got the other language, and probably if you have another language, feel free to do so. But for so long that you have Bahasa Indonesia in
Bahasa.
there.
Okay, that's one thing that is very important to take note, because enforceability, we always make sure that things are well and able to be enforced in the event of dispute. Of course, we don't want the
Correct.
dispute to happen, but I
Yeah.
think as lawyers, the job is to advise in the event of the worst case scenario.
Exactly. That is the point, Nicole.
Okay, thank you so much. Kalvin, we were talking about contract formation.
Okay.
Would currency affect the validity of a clause, for example, or contract in Indonesia? Will you be able to just share more with us on this?
Of course, Nicole. So I think when you do a transaction within Indonesia, Indonesian rupiah is being mandatory to be utilized as the methods of currency. So, but it doesn't actually stop you to put in the agreement that you refer to a certain foreign currency in the agreement as a reference. That one
Okay.
is okay.
Yes.
For so long that you have a clear denomination clause.
Okay.
So at the end of the day, you put a reference on the transaction by utilizing foreign currency and having a clear denomination clause that resulted that the transaction will be, at the end of the day, will be made in Indonesian rupiah.
Okay.
So that will be something that is very, very straightforward and quite useful. So you basically say that, oh, I need to quote in, say, US dollar,
Yes.
right? You still can quote in US dollar by means of quote, putting a reference. But
Okay.
however, under that reference of price, you need to put a clear denomination clause
Okay.
that's stating the procedure on calculating the US dollar into IDR
Okay.
for the purpose of the payment.
Okay.
But the underlying is the transaction need to be made within the region of Indonesia.
Yes.
So when you do import
Mm-hmm.
or when you do export, you actually still can use a foreign currency.
Okay.
Yeah.
It's just that the denomination clause, as you mentioned, is crucial to the
It's-
validity of the contract.
Yeah, for the validity of contract, yes.
Okay. So
Also
just
for the compliance.
also for compliance. Okay. So
Yeah.
just to recap, you've shared that the having the contract in Bahasa Indonesia is critical, as well as having it in having a denominational clause in the
Yes.
contract to say that Indonesian rupiah is the currency of choice for
Correct.
Indonesia contract. Okay.
Correct.
Is there anything else that you would like to mention? For example, when we conclude contracts, we sign on the document. How is Indonesia like in terms of physical signatures versus electronic signatures? Would you be able to share more with us on that?
Yeah. That's very good. So if we remember that during the pandemic times,
Yes.
everyone is working from home.
Yeah, we just came out of that not too long ago, actually.
Not too long ago.
Yes.
So it's very very difficult for people to basically physically sign
Yeah, with wet
the
ink, right?
wet ink, right?
Yes.
So thankfully that there is a platform
Mm-hmm.
to enable the signature,
Mm-hmm.
and uh, it's the e-signature platform for us is something that is very efficient and very effective.
Okay.
But coming to the question about the enforceability and the validity of the e-signature,
Mm.
Indonesia recognized e-signature
Mm-hmm.
through ITE regulation
Okay.
for so long that it met the criteria as mentioned in Article 11
Mm-hmm.
of such regulation. But in short, that I can share with you that when legal counsel want to choose a certain platform for the company,
Yep.
they need to make sure that such platform is basically fall in the criteria in the mentioned regulation.
Okay.
One of it is the ability to submit a certificate,
Mm-hmm.
the ability to have an audit trails, the
Okay.
ability to see that the consent is actually being made.
Mm-hmm.
This can be, this can be happened by in the audit trail. It's clearly mentioned that when the email is being sent, when the document is being sent via email, to who, when that the person opened the email,
Okay.
when the person is reading the content, and then when the person signed, where the person signed,
Mm-hmm.
by looking at the IP address
Okay.
and also looking at the timestamp.
Mm-hmm.
So, and yeah, that is the point of proof evidence
Mm.
that those party actually sign.
Okay. It's a necessary safeguard.
It's a necessary safeguard.
Okay.
So it is advisable to use reputable platform
Okay.
that already commonly being used
Mm.
in for the e-signature,
For e-signatures. Okay.
and double check in terms of the whether those platform is actually have the criteria that as per that is being governed in the IT regulation.
Okay, thank you so much for sharing that. Because I
Yeah.
mean, we live in a very globalized world. It's so
Exactly.
difficult for cross-border transactions to be executed now by way of a wet ink signature because
Yeah.
parties are based in different locations.
Correct.
So it's good to know that Indonesia
Yeah.
law does recognize e-signatures, provided that they comply with the regulations under Indonesian law to
Correct.
ensure that the contract is executed properly by the right parties at the right place
Yeah.
with the right
Exactly.
informed consent.
Yeah.
Yes. Okay.
Yeah. I think it's all in the regulation. But there is a bit of caveat.
There's a caveat. Okay.
Yeah. Not all legal documentation can be signed through the e-signature.
Okay.
For instance, that notarial deeds.
Notarial deeds. Okay.
Yeah, notarial deeds still need to be made by wet ink signature or
Okay.
conventional signature.
Conventional signature. Okay.
Yeah.
Understand.
So those kind of documentation still require basically a wet ink signature. Yes.
Okay. I understand.
Yeah.
Thank you so much for sharing that. If you have found this episode useful, catch the other episodes that we have. This has been Regional Counsel, a video podcast series presented to you by the Singapore Academy of Law.